My name is Mary Goreti Anyango Okoth. I'm an advocate of the High Court of Kenya. I'm a managing partner in a law firm called Okoth Goreti and Company Advocates. So we offer various legal services from conveyancing, which conveyancing is land transactions, to litigation and litigation in whatever form, criminal, civil, commercial, arbitration. So first of all, women, and more so if I look at the Gen X and millennials, in their childhood, and that is in the Kenyan aspect, you'll find most of them engaged in a childhood game used to call kalongolongo or whatever that was it. So in that, they used to anticipate marriage because they will act as a mother and their playmates will be the father. So they're matching in a wedding, they're having a baby, and therefore, and in that game, they never used to play a role in funeral process, separation, divorce, or whatever it is. So women, when they are walking into a relationship, they always foresee staying in that relationship permanently. They don't foresee death. They don't foresee relationship. So most of the time, these eventualities of demise and separation find them blindsided. And then also when a man welcomes a woman to start living together with them, they don't ask questions as to the type of ownership. Let's say Lady X got married to gentleman Y. Then in the course of their marriage or even come with stay relationship, Mr. Y proposes or informs the lady that we are constructing our home. Rarely will this lady start questioning, how are we owning this land? Is it like the man will say, tunajenga nyumba yetu, correct? Rarely will that lady start asking, can I see the title deeds? Then the other misconception again ladies have is they think because you own it, like if their partner own it, you own it. The court doesn't just give you 50% like some women thought, or it's not the man who walks away and leaves you in the home. That thing has changed now. Men now, when you separate, they chase you out of the house. Right now in Kenya, we are in divorce. When you separate, you'll start with the separation, the divorce. Once that is complete, is that when now you'll move to the matrimonial distribution court. So there, it is not automatic because I was married to you or because I bought children for you that I'll be given, I'll acquire part of that property that you also acquired during our relationship. I also again have to prove to court my contribution. So it is very important that a lady in a relationship, you keep records. Unfortunately now, because I know you'll feel like it's too much work, your relationship, you're supposed to trust each other, but at the same time now you're becoming like a watchman, an accountant, an auditor, where I am keeping M-Pesa records so that when that time comes, I don't need to go to Safaricom. Can you go back? I can't remember, was it which month I sent this man money, or he didn't have money to pay the fundi, I paid that money. So it is now very prudent that we also need to take these relationships like any other transaction. When you are now, you are constructing that home. If you became now the foreman, because the man is working and maybe your work is flexible, you are or a stay-at-home mom or work from home basis, when you are overseeing the construction, document it. That is your contribution. That is the contribution you'll tell court, because women will feel like the court was unfair to them. The court was more of a patriarchy court and listen to the man. But you see, the court is a court of records. Court is tied. Their hands are tied. Whatever you bring to them in evidence is what they will consider. So if you document, you create a logbook on the days you spent on this construction site, on what you did, on the M-Pesa message you paid, on whatever money, even if the man spent 15 million in this constructing this house and yours was just 5,000. It increased in value, okay? So that he will be told, how much this house, how much did you spend? 15 million. How much you should bring forth? 5,000. How long was it? What is the 5,000 right now? it is 20,000. You get back your 20,000. So women have to be cautious in that relationship. Keep records, M-Pesa statement. It will save you, because these things, there are eventuality, death and separation. Because in a relationship, women put in a lot. They build the wealth. They raise the family. They make contribution to the acquisition of wealth, whether financial or non-financial. But because of lack of records, when it comes to separation of the couple, they feel disadvantaged. And the court will not help you if you are not prudent. I think Kenyans need to know, because it has been there for a long time, that come we stay courts no longer look at it as marriage. Even traditional, even customary marriage where they take dowry to your home. The law mandates that after you celebrate that ratio, that koito, that nyombo, that malezi or malozi, you register that marriage. Just bearing children and staying with that man for 5-10 years is not marriage. So whenever you talk, even to, if you have friends, because you need not only have friends in the same cadre or discipline of your profession. Have friends all around. Have everybody in your circle. And always take that opportunity to just talk to them and get to know what the law says. Because also when you go to court, ignorance is not a defense. You cannot go to court and defend yourself. Sikujua. Having children does not guarantee you as the wife. Living together, that means now you start bringing photo. You start calling neighbors to testify. Why go through that stress? And that's why I'm saying, while in this relationship, let's be prudent. Let's not wait until that time when we are crying, our eyes are red and so, and then start looking for people to come and talk on your behalf and bring in evidence they have. So even after the coito, have that traditional marriage registered. And nowadays it's easy. You book it online. You get a date. You get there with a witness, because a witness is a must. Just the four of you and you're done. And because also we don't want to lock out the big population or part of population that still advocate for polygamy and they're okay with it. So that traditional, just register it. There's a portion of it is when you go to the AG's office and what we used to call the district offices, which are representative of the AG's in localities, they will advise you how to register the traditional marriage. Because now in that case, you can't go and register a marriage when this man has 2 or 3 wives. When your spouse is deceased, during the life, if they'd put their house in order and went a step ahead and drafted a will, then that is easy, because now you'll only go as per the instructions in the will, the wishes of the man in the will. So in the case that he did not or she did not, then that means now the person died intestate, meaning they never left a will. By the time Kenya was now settling to the law of a Succession Act, and the latest have been revised, I think, in December 2022, it actually looks at the nuclear family. It protects the nuclear family. But again, Kenyans don't know that. They think that if I lose my father today, it is my uncles who will decide how my dad's property will be subdivided. So what Kenyans don't know is that this act, it protects the nuclear family, so that whatever your mother left or owned or your father, it is for this family. It's for the surviving spouse and their children. But because we don't know the law, we let the deceased property, or what we call it estate now, to be administered and distributed by your relatives. But what the law says, if your husband was to die today, whatever he had planned to do or he was doing must be completed. That is the tenets of probate. We call it probate now, the succession laws. that whatever this person had planned to do has to be completed. And also that means, and you've had it in funerals or during that burial ceremony, kama marehemu alikuwa na deni yako, simama. Na kama ulikuwa na deni ya marehemu pia, useme ulipe familia yake. It's actually the law. A widow is entitled to life interest of the deceased property and hold it until, in case of a widow, until they remarry. So there was an uproar, and when the new constitution came in and brought in Article 27 on equality, so that's where now we introduce where a widow, instead of now going back to the act and amending it, widow stroke widower, so we only introduce that where a widow is used, it also means widower. So in case you remarry, then that means you stop holding the life interest on the deceased property. So what happens? The law says that the woman is the surviving spouse, so whether the man or a woman, is entitled to 20% of the residue. So that means after you've paid any debt that was outstanding. So say again, if it was 10 million in the bank account and you owed 2 million, so you remain with 8 million. So the law says you're entitled to 10,000 shillings or 20%, whichever is greater. So of course, if it's 8 million, 20% of 20 billion is higher than 10,000. So the surviving spouse is supposed to take out 20%. That is theirs. And then this remaining one is the one that now they can be distributed among the children. But the only part people are keen on, people are never keen on that section 36(1) of the Law of Succession Act. They're only keen on the section that says that the wife is considered a unit together as the children. So if you had 5 children and your husband has passed on, you included, and now the property is distributed among 6 units, the 5 children including yourself. But they don't look at section 36(1) where you're supposed to get your 20% first before now you are equalized with your children. They only look at that part of where you are equal to your children, where your children insist that they also want to be an administrator with you. And then they look at the part where it is only a life interest, where you remarry, then they disinherit you. And more worse is when you came in as the second spouse. So say the man is kissy and first wife was also kissy. Then they separated legally, and he again legally married you, who is Luya. When you want to start the succession cases, you will start with something we call a chief's letter. So the chief is the one who writes a letter listing the successors. Because the court looks at that chief's letter. That chief's letter has a lot of weight. So much weight that there's nothing you can do without that chief's letter, or you can't go against that chief letter unless now again you start a process in court where you are suing the chief for being malicious. So that chief will even try and bring in children who are not even the deceased. And then they might tell you, huyu alikuwa mtoto wake huko nyumbani. And maybe it's the family who just wants this other person to inherit so that they can take it. So yes, women they are protected by the law, but family disputes and interferences have tried to interfere. And because women always look for peace, they let them engage, they allow them to participate in this succession process. So usually where the will is, after you passes on and you left a will, then whoever you had appointed as your trustee or the executor of that will, because there must be an executor or executrix for a lady, they have to make an application to court attaching that will, because also the court has to confirm, because there are tenets that the will has to abide by. There's some checkbox that the court has to, checklist that the court has to also confirm that they were ticked in drafting of that will. So you make that application, and if the court looks at it and finds it's okay, then gives a go-ahead. So back to what we had said, all this is a commercial agreement. It is your property. You're free to do with it as you wish. So if I bought a land today and decided this land I'm giving it to, I'm even gifting it, or I'm bequeathing. There's gifting and there's bequeathing. So when you gift something, it is as being part of the estate. So when you're giving away through the will, we call it bequeathing. So I'm free to bequeath whosoever I wish. So even if I wish to disinherit my children, as long as that court will look at that will and it ticked all the boxes, so be it. I'll have disinherited my children, I'll have disinherited my spouse. So the only part now, because now if somebody feels like then that will, they feel like it is not fair to them, because now this is just about being not fair to them, is now you have to bring in those records. Again, those records are the ones that will save you. It's like he's not bequeathed me anything in his will, including this house I'm living in. I'll want this court to declare this house as a matrimonial property, and through my contribution A, B, C, D, then if the court is satisfied, that one will be removed from the house, and whoever had been bequeathed that will be disinherited. So records, because with a will, you can't force that person to give you what he acquired through his own sweat and blood. But if you can prove that he wasn't supposed to do that based on law ABCD, because now that is where the Matrimonial Property Act will save you, that whatever you acquire during marriage is a matrimonial property. And just apart from that, you also need to prove a contribution towards some of those matrimonial properties. So first of all, the house you live in, if it's where you had your children, you bear the children, you've raised the children and everything, and you prove to court that is it, where you've lived throughout your years of the matrimonial years, then it will be given to you. And any other property, you have to now prove contribution. So those non-financial records, that is where now the neighbors, friends, and families come in. You have to bring witnesses, because the court is a court of records. You don't just go to court and say, this house is where I have raised all my children. Somebody else has to come and support your claim that this house he has bequeathed it to person X, yet it is the house we have lived in for 20 years. This is where I've had 3 of my children, all 6 of my children. This is where I've raised them. And then you say, I, as a Mary Gority, I would have also gone to work, whether business or employment, but I chose to stay at home to take care of our children. And by deciding to stay home and take care of our children, I saved this man money X. It may not be able to be quantified, but you said because of you staying at home, you saved on nannies, you saved on daycares. You know, nothing stops you from even claiming that you offered therapy to this man. Because every evening when he comes from work and he has to rant about his work, you are listening here. You saved him from going for therapy. So that is your non-financial contribution. Women don't say that, but when those who come to me, I tell them, we are also claiming your non-financial contribution here as therapy. Whether you had a house help, but you were a supervisor, that is your non-financial contribution. Now remember how the house help will have managed that household without a supervisor. Will be the ones that actually budget on the kg of maize to buy, beans to buy, wheat flour to buy, oil to buy, and manage that. The woman is doing that. What women, and I've seen it when men go to court and some women try to say the non-financial contribution, they bring receipts of paying the house help. But the women forget, or their lawyers forget, to argue that aspect of being a supervisor. Because that house help itself, remember the chaos or the trouble the man will be going through, he's at work and the househelp is calling, leo tunapika nini? Do you know that peace of mind the woman has saved you just from being there and telling the househelp tunapika hii leo? So that is your non-financial contribution. Also get to know what you are, because, and then you tell your lawyer. Let your lawyer, because some lawyers they've not done so many family cases for them to know how to push for your right. Or maybe they've been presenting men so much that they don't know what the women, they need to push for the women. Don't blame them. But also you get to ask your lawyer. Don't be afraid because she or he is the lawyer here and they know best. So women, you are keeping quiet. No, ask your lawyer. Ask. Those are your non-financial contribution. Talk about them. So in relationship, women, we need also to be cautious. We need to, because now takes me back when I opened that women go into relationship without looking at the eventuality of separation and demise. So women, we need to, when we are planning, when you're thinking of baby names, also have an exit clause. The way a good lawyer, when a lawyer is drafting an agreement for you, a good agreement must have an exit clause. And an agreement, a business is also just a relationship. So also have an exit clause at the back of your mind. Ask questions in your marriage about ownership. When the man brings in that vehicle, get to know logbook is in whose name. When a man is buying a property, follow up. And then when a land is registered into your names, get to know what kind of ownership it is. Because when you just say we are registering into both of our names, you as my wife and myself, get to know what kind of ownership is that. There is what we call joint tenancy and what we also call tenants in common. Joint tenancy means if now Faith and Brian, you own that property as partners or as spouses, should Brian pass on, then if it was a joint tenancy, you Faith own the whole of it. Not Brian's successors or heirs, you. But tenants in common means if Brian passes on, Brian's property goes to his successors. So be careful. When your lawyer is registering that property, ask those questions. Ask your lawyer, which kind of tenancy have you registered for us in the lands documents when we are signing, when you're going to register it? Have you registered as joint tenants or tenants in common? So in case of now that's a widowhood, you get to know this one is not going to be part of the estate of the deceased. It's already mine. So that one is not discussed. And it should not even be tabled that you already have the house. That is yours. That is the law. Yes, if anybody has a problem with it, they can go and ask the court to declare that section unconstitutional, but it is the law. So if you owned 3 houses and in one of those houses, or your husband owns 3 houses, in one of those houses you are joint tenants, when he passes on, that one now is yours. It don't become part of his estate. It is joint tenants, but if it's tenants in common, 50% of that now becomes part of his estate. So women, start asking questions, start being prudent, keep receipts, keep M-Pesa messages, keep bank statements. Get a lawyer. Let your lawyer become, keeping those records is hard. Be sending those documents to your lawyer, tell them, open my file, I'm sending you this, I'll be sending you the receipts. So, records.